It is 2:14 in the morning on a Tuesday. You did nothing wrong today. You're 9 minutes from your own bed. In your rearview mirror, a black SUV changes lanes behind you. You see a flicker, then another, and your body has already decided for your brain what those lights mean before a single sound reaches your ears. Your pulse jumps. Your palms wet the steering wheel. You ease to the shoulder. You put the car in park. And in the 2 seconds between that and the tap on the glass, your mind starts drafting a defense you have not been asked for. Don't say it. Whatever sentence is forming in your head right now, the thank you for stopping me sentence, the sorry officer sentence, the I was only going sentence, kill it. Because the person walking up to your window has been trained on a script. Every line in that script is designed to build a case against you in the next 60 seconds. And every word you volunteer is a brick in a wall he does not have to make by himself. My name is Daniel Boateng. I spent a decade as a public defender in Cuyahoga County, Ohio, before I ever opened a private practice. I have sat in 412 arraignments. I have reviewed more than 2,000 body cam videos. I have watched good, decent, completely innocent people hand prosecutors their case in the first 60 seconds of a stop, and I have watched them lose it 2 years later in front of a jury. Tonight, I'm going to walk you through the exact moves the officer at your window has been trained to run, the Supreme Court law that already protects you from each one, and the 3 sentences that shut down all 5. Stick around. The 3rd sentence is the one nobody ever thinks to say, and it is the most important one you will learn this year. Drop a comment below telling me which of the 5 you have actually fallen for. I read every one, and I will pick the most stacked scenario for the next video. If this saves you 1 ticket, 1 search, or 1 night you do not want to relive, share it with the people you love. Now back to the shoulder. Here is how this works. The stop has just begun. You have not been asked anything yet. He's still in his cruiser, running your plate, building a profile on you in his head. The clock on his end has been running since you pulled over. The clock on your end starts when you open your mouth. And nothing in your entire life is going to determine the next 3 months of your freedom more than the words you choose in the next 12 seconds. Trick 1 is the window itself. He is watching how far it comes down before he even speaks. In many departments, this is taught by name. A window that goes all the way to the floor reads as compliant. Reads as nervous. Reads as someone with something to hide. A window that drops 2 inches and stops reads as someone who has thought about this before. From a legal standpoint, you're required to be able to hear him, hand him documents, and respond. You can do all 3 through a 2-inch gap, and a Supreme Court case from 1977, Pennsylvania verse. Mimms only goes to the question of what he can order your body to do. It does not authorize him to peer into your life. So let the window drop a fraction, slide your license and registration through the gap, and keep everything else out of his sightline. Trick 2 is the look. He is not just walking to your window. He is sweeping the interior in a pattern drilled into him at the academy. Center console, passenger seat, back seat, floor. Anything visible from outside the car is, under what lawyers call the plain view doctrine, fair game without a warrant. He is also smelling. The claim of an odor, alcohol, cannabis, anything, is one of the most heavily litigated on-ramps to probable cause in American criminal law. You control none of this. The visible open container is visible. His nose is his nose. What you control is what you voluntarily add to the picture. Do not add anything. Trick 3 is the friendly question. He taps the glass, you drop the gap to 3 inches, and he leans down and asks, in the warmest voice in his professional toolkit, "Do you know why I pulled you over tonight?" This is not small talk. It is a deliberate technique with 2 possible answers, both of which help the prosecution. If you say, "I think I might have been speeding, sir," you have just opened body cam evidence of guilt. He does not have to prove the speed. You proved it for him. If you say, "I'm honestly not sure," you have given him a baseline statement he will later compare, line by line, to anything you say on the stand, and the gap between them becomes evidence of evasion. There is a 3rd answer, and I will give you the exact words in 8 minutes. For now, understand that the question itself is the trap. The pleasantness is the lure. Trick 4 is the pause. He says, "License and registration, please." He takes them. He walks back to the cruiser. He does not fill the silence. Human beings, especially anxious ones, cannot tolerate an open silence with a stranger, so you start talking. You tell him where you're coming from, where you're going, who you were with, why you are out this late, what is in the bag on the back seat. Every one of those is a fact he did not have to develop on his own. Every one of those is a thread he gets to pull on for the next 20 minutes, and every one of those is a line in his report you may be asked about 3 months from now, in a witness box under oath. He is not being hostile. He is being quiet. That is the move. Trick 5 is the ask. He comes back, hands you the ticket maybe, and says, almost as an afterthought, "You don't mind if I take a quick look in the car, do you?" Framed as courtesy, framed as a favor, this is the master key. He does not have to tell you that you can say no. So the only protection you actually have is to say no, out loud, before he asks. None of this feels like a trick in the moment. That is by design. It feels like manners. It feels like respect. It feels like the thing your father told you about the police. Be polite. Be honest. You have nothing to hide. Listen to me closely here. That script was not written for your protection. It was written for the report. It benefits the person collecting the evidence. It does not benefit the person handing it over. You can respect the profession and still refuse to hand over the case. Those two things are not opposites. They are how a free citizen is supposed to operate. Now let me show you the law that is already on your side. The Fourth Amendment to the Constitution says you are secure in your person, your house, your papers, and your effects against unreasonable searches and seizures, and that no warrant shall issue without probable cause. The Fifth says you cannot be compelled in any criminal case to be a witness against yourself. The Sixth says you have the right to a lawyer. Those 3 lines of the Constitution are the floor under everything you are about to learn. They have already been protecting you your entire life. What you have not been taught is how to invoke them. That is what tonight is for. Start with the seizure line. In Terry v. Ohio from 1968, the Supreme Court held that a police officer may briefly detain a person only when he has reasonable, articulable suspicion of a specific criminal activity. Not a hunch, not a vibe, not a glance that felt off to him, articulable. Spell it. Facts he can write down. That case created the entire concept of the investigative stop, and it created the question you're going to ask at your window. Am I in a Terry seizure right now, or am I free to drive away? Because if you are not detained, the encounter is voluntary and you can end it. If you are, he has to put a reason on the record. Next, what he can order your body to do. Pennsylvania v. Mimms from 1977 again held that once you are lawfully stopped, the officer can order you out of the car as a matter of officer safety. He does not need extra suspicion for that. So if the next stop, he says, step out of the vehicle, you step out. Calmly. Hands visible. No argument. That is Mimms honoring your safety through his. But Mimms lets him control your body. It does not give him the inside of your car, and stepping out is not the same thing as consenting to a search of what you stepped out of. We are going to draw that line out loud in a minute. Then the clock. Rodriguez Vice, United States, decided in 2015, held that a traffic stop cannot be extended even briefly, beyond the time reasonably required to handle the traffic mission, the speed, the tag, the broken light, to investigate something unrelated like waiting for a drug detection dog to arrive, unless the officer can point to independent reasonable suspicion. Read that again. Once he is done with the ticket, the clock turns on him, not on you. The question, am I being detained or am I free to go, is the device that forces that clock into the open, on the record, in front of his body camera. That question is the only thing standing between a 5-minute stop and a 45-minute fishing expedition. Then consent, the most important concept of the night. Schneckloth v. Bustamonte from 1973 held that voluntary consent to a search removes the warrant requirement entirely, and that the officer is not required to inform you that you have a right to refuse. Read it twice. He does not have to tell you the door exists. He just gets to ask in the friendliest voice he has. And the second you nod, smile, or hand him the keys, a search that would otherwise need a judge's signature becomes legal. Consent is the master key to your vehicle. You are the one holding it. The only way to keep him from using it is to say no, explicitly before he has a chance to interpret your silence as agreement. And silence? This is the trap almost nobody knows about. In Salinas v. Texas from 2013, the Supreme Court held that pre-Miranda silence, that is, going quiet during a voluntary interview before you have been arrested, can be used against you at trial as evidence of consciousness of guilt. In Berghuis v. Thompkins from 2010, the court held that to actually invoke your right to remain silent, you must do it unambiguously. Sitting there, not talking, is not invocation. Saying, in your head, I should not answer, is not invocation. You have to open your mouth and say the words, otherwise your silence is not a shield. It is an exhibit. The prosecutor walks to the jury and says, ladies and gentlemen, an innocent person would have spoken. He stayed quiet. Ask yourselves why. That is admissible. That is legal. And that is what Salinas and Berghuis mean when you have not invoked. So here is how this stacks up against the 3 default strategies you were probably raised on. Move 1. Talk your way out. You cannot. Every sentence past license and registration is either an admission, a lock-in to a future story, or a quiet consent. The cases we prosecuted at my old office that were the easiest to win were the ones where the driver told the story himself. The report practically wrote itself. Move 2. Just go quiet. You cannot the way you think. Under Salinas and Berghuis, silence without express invocation is treated as evidence of evasion. The prosecutor stands up and reads your quiet back to the jury like a confession. Move 3. Just act natural. You cannot. Shaky hands, avoiding eye contact, glancing at the glove box, looking at the passenger seat. Every one of those becomes a furtive movement or an indicator of deception in the narrative portion of his report. Nerves are involuntary. The report is not. So the 3 moves that feel like doors are all locked. There is no door there. What there is a 4th door, and an exact set of words for it. Hear me before we get there. This is not a magic spell. If he has probable cause, he still has probable cause. If he has decided to write the citation gets written. Your win tonight is almost never getting out of the stop with nothing at all. Your win is making sure that 3 months from now, when you walk into a courtroom with a lawyer, his case against you has nothing on it that you handed over. That is what these words do. They preserve the fight you were always meant to have in court, not on the shoulder. Here are the 3 sentences. Memorize them. You deliver them at a level voice, eyes forward, hands in sight, into the space between his face and your window, where the microphone will catch every syllable. Officer, am I being detained or am I free to go? I do not consent to any searches of my car or my person. I'm invoking my right to remain silent, and I will not answer any questions without a lawyer present. That is it. 3 sentences, 12 seconds. The order is not decorative. Let me walk you through why every piece is in the place it is in. Clause 1. Am I being detained, or am I free to go? That is the Terry question, said out loud while his body camera is rolling. He now has 2 and only 2 options on the record. He can say you're free to go, in which case the encounter ends and you drive home. Or he has to admit you are being detained, in which case, under Rodriguez, the clock is now running and he has to point to articulable reasons to keep you there. Either answer helps you. There is no answer that hurts you. That is why it goes first. Clause 2. I do not consent to any searches of my car or my person. That is Schneckloth said back out loud, in the only version of it that you control. If he searches anyway, he has to justify it later. Probable cause, a warrant exception, or have nothing. If it is nothing, the search is suppressed at your motion hearing. Everything he finds inside it goes with it. That is the fruit of the poisonous tree doctrine, and it is your biggest ally in any drug paraphernalia, firearm, or mere possession case. Without clause, 2 said out loud, a shrug, a smile, or an unlocked door becomes consent. With clause 2, none of those moves the needle. Clause 3. I am invoking my right to remain silent, and I will not answer any questions without my lawyer present. This is the line everyone forgets, and it is the most important one you will say tonight. Salinas and Berghuis together mean silence on its own is not enough. You have to announce it. You have to name the right. You have to name the condition for ending it. This sentence is unambiguous. It is on the record. Once you say it, every question that follows without a lawyer present becomes a problem for the officer's case, not yours. And in the order things arrive. Detention first, because if you are free to go, none of the rest is necessary. Consent second, because that is the trick he's most likely to run next and you want it on the record before he asks. Silence third, because it closes the door and seals the record. The tone rule, hear it. Not loud, not sarcastic, not angry, not smug. You are not scoring a debate point, you are creating a record. Level voice, eyes forward, hands where he can see them. Firm, polite, recorded. That is the corridor. Anything hotter, he writes hostile in the narrative and uses it. Anything softer, it does not read as invocation. Stay in the corridor. Now, the part nobody prepares you for, he is not going to say, okay, drive safe, have a good night, the first time you say those 3 sentences. He's been trained to push back. Here's the ladder. Rung 1, the guilt pitch. If you've got nothing to hide, why won't you let me take a look? This is the oldest play in the book, and it works on 9 out of 10 drivers because on the surface it sounds like a question about morality. Your backup line, word for word, is, Officer, I'm not saying I have anything to hide. I am saying I do not consent to any searches. Am I free to go? Same corridor, same tone. The trap was the question. The escape is the question back. Rung 2, the body. He says, step out of the vehicle. Under Pennsylvania verse, Mimms, he can order you out of a lawfully stopped car. So you step out, calmly, hands visible. No argument, no reaching, no running. I mean this as a lawyer and as someone who wants you alive at the end of the night. That order is one you follow. Never fight on the shoulder of a road. You always win the fight in a courtroom 2 years later. But as you step out, you say calmly, the same line, Officer, I am stepping out as you asked. I do not consent to any searches of my car or my person. Mimms lets him move your body. It does not let him search the body or the trunk you stepped out of. Rung 3, the nose. He says, I smell alcohol, or I smell marijuana. The word. Now, the law on what an odor of marijuana alone will support has been shifting jurisdiction by jurisdiction for the last several years, and that is a place where the generalizations in this video run out. The lines that follow, however, are the same in every state. Do not argue the smell, do not deny it. You say, I understand, officer, I still do not consent to any searches. Am I free to go? You deny the search. You do not deny the officer, and you do not give him evidence of an attitude problem to put in his narrative. Wrong 4. The bluff. Some version of, we can do this the easy way or the hard way, or I'm just going to go get a warrant anyway, so why don't we save both of us the trouble? Under Frazier v. Cupp from 1969, the Supreme Court has held that officers are permitted to use deception during questioning, including bluffing about a warrant they may or may not be able to get. That is the legal status of the threat. The right answer is unchanged. If he can get a warrant, let him get one. That is not obstruction. That is the system working as designed with the checks the founders built into it. Your backup line is, you are welcome to do what you are required to do, officer. I still do not consent to any searches. Am I free to go? That is it. The threat was the play. The question is the finisher. Whatever rung he climbs to, you do not escalate, you do not reach, you do not run, you do not record him on your own phone in a way that creates a confrontation. You stay in the corridor, firm, polite, recorded. As a defense lawyer and as someone who has done this work for 20 years, I have never once watched a client win a physical confrontation on the side of a road. The fight you win is the one in chambers, in a suit, in front of a judge, 3 months from now, on a cold record where his body camera is the witness and your lawyer is the one asking questions. Let me put the entire night on one card in your head. Window cracks 2 or 3 inches, license and registration through the gap. When the officer taps the glass, you do not answer the "why did you pull me over" question. You go straight to the 3 sentences. Officer, am I being detained or am I free to go? I do not consent to any searches of my car or my person. I am invoking my right to remain silent, and I will not answer any questions without a lawyer present. If he plays the nothing to hide card, you go back to the backup line. If he says step out, you step out calmly, hands visible, and you restate the same line. If he claims an odor, you then